As usual, arguments start with the attorney for the petitioner.
Thank you, Mr. Chief Justice, and may it please the Court. This Court has long safeguarded the right of association by protecting the membership and donor lists of nonprofit organizations like First Choice. Yet the Attorney General of New Jersey issued a sweeping subpoena commanding, on pain of contempt, that First Choice produce donor names, addresses, and phone numbers so his office could contact and question them. That violates the right of association.
Ms. Hawley's opening argument may be true, but I still have a problem with it. Yes, if the state of New Jersey can simply demand the information of people who associate with a group, then it violates their right of association. However, the First Amendment does not protect people from such violations by a state, only those done by laws made by Congress. The First Amendment reads, "Congress shall make no law abridging the right of the people to peaceably assemble." The Constitution of the state of New Jersey does protect its citizens. The people have the right to freely assemble together. Not only is this rather important detail missed by both the attorneys and justices of the Supreme Court, but lower courts had some interesting views as well.
Yet the lower courts held that First Choice must litigate its First Amendment claims in state court. That violates this Court's decision in Nick, contradicts the Court's virtually unflagging obligation to decide cases within their jurisdiction, and runs contrary to Section 1983. Even the Attorney General now agrees as much.
There is a serious constitutional issue with the claims of the lower courts. State courts do not have jurisdiction over First Amendment issues, only federal ones. From Article 3 of the Constitution, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. So how can a state court litigate a case that the Constitution clearly states is under the judicial power of the United States, i.e. federal courts?
His newest rationale for evading review, questioning First Choice's chilling injury, fails for two reasons. First, First Choice's associational interests were harmed the moment it received a coercive subpoena demanding donor names on pain of contempt. This is true irrespective of whether the subpoena is non-self-executing, for even an unenforceable threat may chill First Amendment freedom.
There was a fair amount of discussion regarding chilling injury, that the actions of the New Jersey Attorney General chill the ability of the First Choice to acquire and maintain donors. We'll talk about that later.
Second, the Attorney General does not dispute that First Choice faces a credible threat of enforcement. And there's no question that First Choice's First Amendment interests are arguably burdened by the subpoena. This Court's cases require no more. The Attorney General's proposed subpoena exception from ordinary Article 3 rules would mean that the NAACP could have received a hostile subpoena from an Attorney General, and federal court review would not have been available until a state court ordered production. But then, Younger abstention and res judicata would almost certainly slam the federal courthouse doors shut.
The other major point of discussion was whether or not there was credible threat against First Choice. First Choice has a simple ask.
This Court should reverse and hold that this subpoena violates the First Amendment and satisfies Article 3.
I agree that the lower court decision should be reversed and that the case belongs in an Article 3 court. But I disagree that the subpoena violates the First Amendment, because what it does is violate the Fourth Amendment.